She admits that, right now the child is calling two people father. I don't initially have a real problem with that.
It took some time for service. Mom would claim that she wasn't who she was, so my process server had a hard time serving her. They seem to get along for the most part, unless mom gets mad at dad for some apparent reason.
Basically, Mr. McKediak has an extremely extensive criminal history, and the court originally ordered that he would have no contact with the children. Additionally, another conviction in 2023, it's listed as assaulting a pregnant individual.
And there was an incident earlier this year with regards to he leaving the children home alone. At this point in time, he's moved 3 times and with 3 different women since entry of the judgment.
I gave her a settlement of $523,117. It's very unfair that I've complied with the judgment, and now this is causing me harm.
Stephanie Brannen versus Castile Brannen.
Court will note the appearance of Ms. Reed on behalf of plaintiff, Mr. Bland on behalf of the defendant. This matter is before the court on the defendant's motion for custody, parenting time, and other relief. Mr. Bland, you can proceed.
Thank you, Your Honor. We are dealing with one child here, and her name is Elizabeth. She's, I think, age 5 at this point, and I think she's just started school in Marshall. So Mr. Castile has visited this matter before. He's back before the court because, well, frankly, he believes that there's been a change in circumstances that would justify visiting the custody factors. First off, he reports that the child has had a dog bite. I know, and mom in her response said that she denied that, but at this point I can only list I guess what he says that has happened. Secondly, and I think this is important, although mom in her answer kind of poo-poos it, so to speak, he has moved closer to the child. They were, I think mom says they were 18 miles apart, and that wasn't she thought a big deal, but they both now live in Marshall. I think that gives him a lot more opportunities to be involved. I know mom will argue, well, he could have been involved before and so forth, but essentially they live in the same town. There's some dispute about the next factor, but I think the next factor is being informed of certain things. Mom's attached things, saying where she has informed dad of certain activities and so forth. But, I think it goes beyond that. One of the exhibits I thought was kind of telling, and I think it's exhibit 2. And in that, it's in a text exchange, or maybe email, not quite sure anymore, between Mr. Branham and Ms. Brody. And it says, this is Mr. Branham speaking, saying, look, I have different opinions on her educational platform and so forth. Right now, mom's got soul legal and soul physical. So dad's opinions are kind of just that, opinion. So I think it goes more beyond information. She admits that, right now the child is calling two people father. I don't initially have a real problem with that. I mean, I think kids ought to be allowed to call the people in their lives who they want to call them. That's not the issue. The issue is Mr. Branham spending enough time with this child? And even mom says, she goes, well, at the beginning he wasn't, and that's why this child does that. Again, this isn't to fault the child necessarily. This isn't actually to fault mom. What this is to say is, well, I think dad does need some more time. He says he can take care of her. I guess mom disputes that. But part of this, and again, mom disabuses most of what I say, and I appreciate that. She's got an able advocate. But, there was a very tortured beginning to starting this. He didn't really have much time. He wasn't taking advantage of time. I think over the past period of time since the last order, he's done that. I'm not aware that he's missed any time or so forth. He's created this bond with the child. He wants to be more involved. He wants to have more time. He's lived closer. I think circumstances have changed enough in terms of going beyond informational access, spending more time with the child, and having some say in actually the school system that he now lives in. So in any event, Judge, I'd leave it at that. Thank you.
Okay, thank you. Ms. Reed?
Your Honor, there has not been a proper cause or change in circumstance to address parenting time, let alone custody. The move that has occurred is an 8-minute difference between where Mr. Branham lived previously and where he lives now. There wasn't a dog bite. In the Our Family Wizard messages that we attached, my client has kept Mr. Branham informed of every single school event. There haven't been any medical events or any medical doctor's appointments. This is a healthy child to make him aware of. He has complete access to all that information. The child does call another man dad, and that's because Mr. Branham was voluntarily absent for years. My client, as mentioned in our response and backed up by the affidavit or memorandum provided by my client's employer and her superior, she's in a non-deployable status. She's not going anywhere, and her employment hasn't changed in years. There is a years-long history of Mr. Branham harassing my client, threatening to have her terminated from her employment, threatening to kill himself. All of these threats that resulted in 2 PPOs. This is the last 6 months is the longest that he's been able to behave himself in the last couple of years. We're asking that this motion be denied because an 8-minute move or moving 8 minutes closer is not proper cause or change in circumstance to change sole legal custody to joint legal custody or drastically change the parenting time. Mr. Branham has sufficient parenting time to establish and continue the relationship with the minor child. He's currently exercising standard parenting time, and this is a frivolous motion, so we're also asking for attorney's fees.
Thank you. Mr. Bland, anything else?
I'll leave it to the court.
Okay. Well, in this matter, the court has reviewed the pleadings. I note that, again, the plaintiff has responded to the defendant's allegations. It does appear that the defendant was absent from the child's life for a substantial period of time. The plaintiff states approximately 4 years, but and then he did have a phased-in parenting time schedule with supervised parenting time, and then he went to the standard parenting time in the third phase. When I review this, the court does not believe that there is proper cause or change in circumstances sufficient to meet the Vodbarka threshold for an evidentiary hearing. As a result, the court will deny the motion. Ms. Reed, I'll ask that you would prepare an order denying the motion.
Okay, denying attorney's fees as well?
No, I'm not going to order attorney fees at this time.
Okay,
Thank you. You're free to
Thank
go
you, Your
ahead
Honor.
today.
thank you.
Today is Monday, April 29th, 2024 at 9:04 a.m.
Court will note the appearance of Mr. Seisel in this matter on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for entry of UCSO. Mr. Seisel.
Morning, Your Honor. This custody matter was initiated by a plaintiff's mother some time ago, and a bench trial was scheduled for February 6, 2024. And after briefly starting that trial, Your Honor, the parties stipulated to a judgment regarding custody and parenting time, and also a mechanism for the entry or the calculation of child support. In that stipulated judgment, it provides the front of the court would gather the parties' respective income information and then calculates.
Mr. Seisel is apparently froze up, so we'll have to wait.
Okay, I dropped off there for a second somehow.
We dropped off
and
after
so
stating
I'll just-
that the front of the court was going to calculate.
Okay, thank you, Your Honor. And yes, so the stipulation was that the front of the court would gather the parties. Time.
You're broken
After
up.
plaintiff would submit.
You're broken up, Mr. Seisel. We're only catching about every second or third word.
Did I try to just connect by my phone?
Well, try now. We can hear you now. Try finish, and then hopefully we can get through it.
Okay. Sounds good. And so the parties did that. The front of the court did conduct its review. They gathered the parties' income information, then calculated support based on the stipulated judgment with respect to parenting time. Exhibit B attached to the motion is the approved uniform child support order approved by the front of the court. So all conditions have been met in the judgment. So we would ask at this point in time that the uniform child support order be entered by the court.
Okay, thank you. Mr. Bishop, what's your position?
I'm aware of what we're here for. I have the paperwork in front of me of this order that they compiled. And I do see here if I disagree with this recommendation, I can file a written objection within 21 days.
Well, that's the result of a referee hearing and did you have a referee hearing, Mr. Seisel?
No, we did not. This just went to the front of the court.
Okay, well. Then that wouldn't be applicable, Mr. Bishop, because you didn't have a referee hearing. I don't know why that's in the order.
Okay.
What's your position? Anything else?
No, just
Okay.
that I don't completely agree with, I don't know if it's taken into consideration that I pay child support on another child, and also the in my line of work, the hours fluctuate so much from sometimes it's 32, sometimes it's 40, sometimes it's 26. I don't think things were taken into consideration on that note. They just acquired the information from.
Well, what they would have done is they would have acquired your most recent income information for that period of time was in the year, and then they would have divided it by the week, so it would have been averaged out. You wouldn't have been paying at the, let's say, at the highest weekly amount, nor at the lowest weekly amount. They would have taken it and averaged it out.
Oh, okay. Because it just looks here like it's based off me making $1,000 a week, and I do not make that.
Okay. Mr. Seisel, do you know, did he get a other child credit adjustment?
I would have to pull up the initial paperwork from the front of the court, which I don't have in front of me right now, Your Honor. See if I can find that real quickly.
Well, if you can look it up, I'd appreciate it. I've got the support recommendation, but I don't have the calculation. Well, if I'm looking at Mr. Seisel, I'm looking at the UCSO and the calculation, and it doesn't, under other, it doesn't show any other child, again, credit in this particular matter. So based on what I can see, and I don't have obviously all of the information, but based on what I can see, it doesn't appear that it would be an accurate support calculation. What I'll do, Mr. Seisel, is let you look at this, recalculate and resubmit a UCSO under 7-day notice of entry, and giving Mr. Bishop credit for the other child deduction.
Calculation from the Fs. I'll take a look, and if I see that the FOC did provide the initial or the other child calculation in there, I guess I'll just resubmit on our 7-day and add the FOC.
That's fine, and if you would, when you send that out, send out, if in fact it turns out that Mr. Bishop was given credit, would you highlight that in the calculation and provide that to him with the resubmission of the order?
Yep, we will.
Oh, okay. Because based on what I'm saying, I looked at the support recommendation and the UCSO that I have, and it doesn't show that. That might very well be. I can't see from what is in the file that he received that credit. Okay.
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 And
That will take care of it.
Yep, and I believe that case is in Kalamazoo. Is that correct? I don't know if Mr. Bishop can speak to that.
Mr. Bishop, is your other case in Kalamazoo?
Yes.
Okay.
And what is the amount of child support being paid?
The exact amount I do not know off the top of my head. It just comes right out.
Okay, well, what you're gonna have to do, Mr. Bishop, if you want to get this correct, you're gonna have to provide Mr. Seisel with the amount of the support, because he can't deduct that if he doesn't know
Okay.
what it is.
Okay. Every week's $112.
And 12 per week.
Correct.
Okay.
Maybe some change.
Okay. Okay, Mr. Seisel, you look like you can calculate that and then resubmit it under 7-day.
Yeah, and
Okay.
I think I may have found it here real quickly.
Okay,
Okay. Yep, I'll do the follow-up work and then I'll submit the appropriate amended UCSO.
well, if you
USDO.
would too, as I'm looking back through, I see the last front of the court objection that we had the, looks like the medical was, the percentages were incorrect. That order had
Yep.
50-50, and they're saying the last objection they had dated, April 10th said it should have been 62-38%. So
Correct, which was
make
changed.
that
Yep.
make that correction as well.
Yep, that should have been made already. I think that should
Okay,
be in the.
I was just looking at the order that we had, is all.
Yep.
So, okay, thank you. Resubmit it. That'll take care of it. You have an excuse. Have a good day.
Okay, thank you, you too.
You too.
Court will note the appearance of Ms. Sachs on behalf of plaintiff. This matter was adjourned from last week under the plaintiff's motion to dismiss to allow the defendant to file a counter complaint. The defendant has filed the counter complaint. Ms. Sachs, have you received that?
I have, Your Honor.
Okay. Anything else in regard to your motion?
No, Your Honor, I would just state that we have not received any sort of discovery. We have not even received financial disclosures, and we'd ask that this court set a timeline for those at this time.
Well, at this point, they're already by court rules, a timeline to do the financial disclosure, so the court doesn't need to again reiterate that. What we'll do is, now that we probably need to do a scheduling order. We didn't previously, did we?
We did, Your Honor. Mr. Matthew filed his answer over 28 days ago, so we're beyond the 28 days allowed for disclosures, which is why I asked for the firm deadline by which the parties need to exchange them. Did we file a schedule?
Yeah, we're checking to see if a scheduling order was done.
Settlement conference is scheduled for June 3rd at 1:30.
Okay. Well, there was a case scheduling order completed, so that has the discovery deadlines in it, so the court will not reiterate that, simply rely upon that. Mr. Merrithew, there are things that you have to do at this point. One of those is you have to do a financial verification pursuant to court rule. Apparently you have not done that yet. You need to do that. And
Yes,
then
sir.
comply with any other deadlines that are in that case scheduling order. So at this point, the court, based upon that, Ms. Sachs, you can do, court will allow you to withdraw if you wish to, withdraw your complaint. But then we'll proceed on the counter complaint. It's up to you on what you want to do.
That would be up to my client, Your Honor, whether she would like to withdraw the counter complaint.
Okay, you can talk to
Or withdraw her complaint.
the complaint. You can talk to her and figure it out, and then file the withdrawal if you wish to do so.
Understood, Your Honor. Thank you.
Okay, thank you. You're free to go. Have a good day. Court will note the appearance of Ms. Sachs on behalf of plaintiff, Ms. Savage on behalf of defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time, support, temporary restraining order. In this matter, Ms. Sachs.
Good morning, Your Honor.
Good
Ms.
morning.
Larson brings this motion partially due to the need for a temporary mutual restraining order between the parties as regards the disposal, waste, or otherwise transfer of assets. Specifically, in this case, we are worried about the marital home due to its current state and our concern that it would not remain in even its current state. We are also asking for temporary orders as regards to the children. The children have a sole custodial environment with Miss Larson. They currently reside with Miss Larson. She's doing 100% of the childcare, something that pre-existed the couple's separation. She has fled to this jurisdiction to escape domestic violence perpetrated by defendant, and she did so to escape that conduct and as well to escape the conduct that was being done against the minor children. There is currently a PPO in this case, as well as a CPS safety plan. The safety plan explicitly tells Miss Larson that she is not to have defendant have unsupervised conduct with the minor children. And for those reasons, Ms. Larson is requesting temporary sole legal and physical custody with the understanding, of course, that she will keep Mr. Larson reasonably informed of what is going on with the children. As well as we're requesting that supervised parenting time is granted to Mr. Larson, given that supervised parenting time is allowed per the CPS order. We'd ask that that be facilitated through Family and Child Services for the safety of both parties as well as the children.
Okay, Ms. Savage, what's your response?
Your Honor, with respect to the marital home, there's a lot left unsaid here. First of all, this is a land contract that the status is questionable. Apparently, the parties haven't made payments in years toward the home. And as to the condition of it, there were 2 adults living in this home until very recently, either of whom could have cleaned it up, and neither of them did. And so to put the blame on Mr. Larson is a bit questionable. With respect to the waste, it's hard to walk through the place. We're going to have to deal with the massive amount of property that Mrs. Larson left behind. And so I hope that after this call, we can have a conversation about how to dispose of that or how to get it out of there so that the place can be cleaned up. But beyond that, the restraining order with respect to assets is fine. With respect to custody and parenting time, my client disputes much of what's in the order. For whatever reason, this case was filed in Calhoun County, even though the PPO was litigated in Ingham County. There isn't a lot of detail attached to the motion as to the specific allegations. And with respect to domestic violence against Mrs. Larson or the kids, he disputes all of it. So in conclusion, Your Honor, temporary sole legal custody, provided he is informed of the major decisions respecting the children, is acceptable, provided supervised parenting time is arranged in short order, and that there's a path here to restoring full parenting time for my client. I think both parties should comply with the recommendations of CPS, including any necessary classes. And I would like an order to attend mediation if we can't work this out, Your Honor. Beyond
Okay.
that, the relief is fine.
Well, we'll deal with that when we have our scheduling conference. Well, in this matter, what the court's going to do is, as stated, there is a CPS safety plan that provides only for supervised contact with the defendant in this matter. So as a result, and based upon the history and the court maintaining the status quo, the court will grant to the plaintiff custody in this matter. Court will grant supervised parenting time to defendant supervised by Family Children's Services. Further, there was a request for our family wizard for the communication of the parties. The court will, in fact, order that the parties would communicate through our family wizard if they need to. Court will further provide for an injunction in this matter against disposing, dissipating, wasting, or otherwise impairing any of the assets of the parties. And the court would order support consistent with the incomes of the parties in this matter. And I'll ask Ms. Sachs that you would prepare that appropriate order. Anything else, Ms. Sachs?
Your Honor, can we just get Mr. Larson's current income and hours for the purposes of the support order?
Okay, what I'll do is I'll just, Ms. Savage, if you would provide that income or that information to Ms. Sachs, then she can calculate the support. She'll provide you information concerning her client's income as well.
Certainly, Your Honor.
Okay, thank you.
Thank you, Your Honor.
You're free to go. Have a good day. Court will note the appearance of Mr. Carroll on behalf of the plaintiff, defendant in parent improper. This matter is before the court on the plaintiff's motion for a therapist for the child, as well as a review of support and for telephonic communication. Mr. Carroll.
Thank you, Judge. Good morning. I've not received an answer from the defendant, but in this case, Judge, the minor child, Kelsey, 16 years of age, she had been expressing, and school personnel actually brought to my client's attention, issues of depression, low self-esteem. My client brought that to the attention of the defendant, saying he'd like to have her meet with a counselor, a therapist, actually contacted someone with Rooted Counseling, and basically he said, "I'll see you in court." And unfortunately, that's what leads me to be here for this purpose, Judge. We'd like to have this 16-year-old get involved in some kind of therapy, some treatment. As it's turned out, it's even gone to the worst, Judge. Now, as my understanding is, Kelsey is not going to see her dad. It's even got to the point where when his wife, the stepmother, tries to pick her up from school, she does not, I guess, get in the car with her or leave with her. And perhaps this therapy should have started back in February when my client was interested in it. But at this point, we'd like to use Rooted Counseling. They're out of East Lansing. Back then, they did have somebody available by the name of Jessica Lundy. When my client explained to Miss Lundy that they had joint physical, Miss Lundy advised that they would need an agreement of consent from dad. And obviously, without your assistance, we will not get a consent from dad. That's assuming that that therapist is still available. I know this court's probably aware that since COVID, in particular with teenagers, there has been a tremendous amount of mental health counseling going on. As to the next issue, if the court, I couldn't believe it when my client said child support in this case has not been reviewed since 2009, Judge. And ultimately, there's been a significant change in circumstances to justify a support review. If I had the information, I could run the guidelines. I was watching the court earlier this morning, but I don't. So either we can refer it to the front of the court, or you can order that the defendant provide me with his W-2s from 2023, and then I'll run the support at that time. And then I asked in this case, the reason I mentioned the telephonic communication is Kelsey has a cell phone, as this court's probably aware. Most teenagers do. Evidently, there's some restrictions on whether that phone can go to her dad's house or not. So my client was concerned, well, when she was at dad's house, how could she communicate with her? Well, it appears now Kelsey's maybe against my client's advice and her and encouraging, she's decided she's not going to see dad. And that's obviously not what we want. We want to see her see dad, but we want to make sure that that relationship is healthy and that this young lady is not in risk of having school personnel worried about her health and her mental health in particular. So essentially that's it, Judge. I don't know what the defense is going to say because I've not received any kind of answer.
Okay. Mr. Kennedy, do you have any problem with providing your W-2s to Mr. Carroll?
I do not. Are you wanting, you had referred to my LLC, that is filed for an extension. So I won't be able to get you that for the LLC. In 2022, the plaintiff has said that I had earnings. The company was just established in 2022, no earnings. So there would be no tax return on that. 2020.
Okay, let's do this. Rather than that, if you've got an LLC and we're going to have to do that, court will simply send that matter to the referee for an evidentiary hearing on child support.
Okay.
Sir, what's your response to the rest of the motion as it relates to a therapist or for the telephone communication?
In 2019, I had contacted the plaintiff about seeing a psychiatrist or a psychologist for Kelsey because we had the same problems that back in 2019 or there just after. And she told me the same thing. I've got text messages that show I did say no.
Sir, I don't care what happened in 2019. I'm asking now,
Okay.
do you have a problem with the child going into therapy?
With standards, no. With what the plaintiff normally does is takes our daughter to medical, any type of medical, and I don't get a say in that. There's been several instances, and then she asked me to come up with money to pay that bill. She's got 3 different insurances that she doesn't utilize. And then I'm stuck having to pay portions of that.
Okay,
So
what the court will do is the court will order that the child participate in some counseling. If it's with this Elizabeth Lundy, then fine. If it's somebody else within that office, Mr. Carroll, if you could provide the defendant with all of the information, contact information for the counselor. So again, it'll be Miss Lundy or somebody else in that office. The court would order
Judge.
the parties would equally pay the cost of the counseling after all available insurance is utilized.
What if the insurance does not pick up that office because
Then you end up, you'll end
50.
up having to pay 1/2 the cost of the counseling.
half or court order states that I have to pay 25%? Are we still abiding
Nope,
by?
I'm ordering counseling at 50%.
Okay.
Judge, if I may, I know my client, the counselor likes to communicate through email, as many of us do. Unfortunately, the defendant has refused to give the plaintiff his email address. Would the court please have him provide that? So,
Well, what we can do is I've told you to give him information on contact. He
Yeah.
can contact Miss Lundy or whoever is going to be doing it, and he can provide that information to him. We're not going to babysit him and
okay.
walk him through it.
All right, Judge, not a problem. He has her contact information, but I'll make sure he gets it again.
Okay. That will be the order of the court. Mr. Carroll, you can prepare an order that reflects that. Oh, I did have, if in fact the child does go to the defendant for parenting time, she will have access to her phone and she can talk to the plaintiff for 10 minutes per day that she's at the defendant's home between the hours of 6 p.m. and 7 p.m.
May I
Thank you,
brief on
Judge.
the judge?
Yeah, you can, but I've already ordered it, so.
Well,
Go ahead.
so
Do you
what
wanna
the
respond?
restrictions was for is she already had a phone at my house. Her mom bought another phone, so she didn't have restrictions on the phone that was at my house. She had
Okay.
restrictions on the secondary phone.
Okay, so you don't care when she contacts the plaintiff?
No.
Okay, then the court won't put that restriction on and she just has access. Again, I'm going to state she can use her phone for that. She doesn't have to use the phone you have at your home. She can use the phone that she has as long as she has that phone, so. Mr. Carroll, you can submit the order under 7-day notice of entry.
I will, Judge. Thank you. Have a
Okay,
good
thank
morning.
you. Have a good day. Court will note the appearance of Ms. Paisno on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for temporary custody and parenting time. Ms. Paisno.
Thank you, Your Honor. I know the court's reviewed the pleadings. We filed back in January. It took some time for service. Mom would claim that she wasn't who she was, so my process server had a hard time serving her. As this court's aware, there's one minor child that's currently 11 months old. We have two parents that deeply love this minor child and have been very involved in the minor child's life since birth. My client is employed at Esper Electric, where he works Monday through Friday from 7 to 3:30 p.m. Mom works second shift at Target Distribution Centers from Tuesdays through Fridays, where she works, I'm now told, from 3 p.m. to 1 a.m. My client has been actively involved in all the doctor's appointments. He attends doctor's appointments. He tries to communicate with mom about important issues. They seem to get along for the most part, unless mom gets mad at dad for some apparent reason. My client, only at mom's discretion, has been exercising Thursdays and Fridays and sometimes a weekend visit. Since we filed this, prior to that, it was a little bit more. My client does own his own home. He has a 4-bedroom home that the child has its own bedroom. Dad has and always does provide all the necessities for Sophia, being diapers, food, clothing, any kind of medical care that's needed. My client does have daycare providers, his grandma and his aunt, who are able to watch the minor child during his time. What's happening right now on Thursdays and Fridays, my client will pick the child up from daycare at 3 or 3:30. Mom then demands that she come and pick the child up between 1 and 1:30 a.m., which is not in this minor child's best interest. She then drives the child 30 minutes back to Battle Creek because my client resides in Kalamazoo. What we're asking for today is a temporary order, asking that this court enter an order allowing my client to have the minor children while mom is at work. So Tuesdays through Fridays, and then one weekend a month. That way the minor child will have stability and consistency, which is important for this minor child, rather than being woken up in the middle of the night for mom to pick up the minor child. Mom has not filed an answer in this case. I have not received any communication from her, so I don't know her stance on anything. What we're asking for is this court enter a temporary order regarding joint legal and joint physical custody, with my client, as I indicated, having Tuesday, Wednesday, Thursday, and Friday overnights with dad, and 1 weekend a month, and the remaining time with mom.
Okay, thank you. Ms. Murray, what's your response?
I would like to ask for an adjournment so I could retain a lawyer. I have part of the money saved up, but I could not find a lawyer in time that I could afford.
Okay. The court obviously will always let someone get an attorney. Are you gonna need a week or 2 weeks, ma'am?
At least 2 weeks.
Well, not say at least, I'm giving you 2 weeks, that's it. So.
Yes.
Because I'm not gonna drag this out, I would state to you during the interim, you should allow the plaintiff to have time with the child. If you don't, the court will consider that at the next hearing as well. So I'll adjourn the matter 2 weeks. We'll have it at the same time at 9:30, and that will be on May 13th.
Yes, Your Honor.
Okay. Thank you. We will deal with it at that time. Have a good day.
Thank you, Your Honor.
Thank you.
This matter is before the court on the defendant's motion to set aside default. The default having been entered on January 30, 2024. The basis, Ms. Perkins, as you state, and I quote, "I didn't realize that I was required to file an answer," end quote. Is that the basis for setting aside the default?
Yes.
Okay. Well, let me tell you, the summons that is issued with the complaint, the summons says you are being sued. You must answer within the appropriate days, or a default will be entered against you. So your statement that you didn't realize that you had to file an answer is not a basis to set aside the default. It's a result of your own negligence in this matter. But what will happen, the court will deny the motion to set aside the default, but I will allow you to participate in the disputed matters. And what we will do is we will set the matter for mediation.
Okay.
Mr. Perkins, do you have that'd be an attorney mediator? Do you have any individual you would recommend for mediation?
No, I do not. I don't have
Okay.
any representation.
Okay. Ms. Perkins,
Yes.
do you have someone to recommend for the mediator?
No, I don't.
Okay. What we will do is then we will send it to the mediation clerk, and the mediation clerk will then randomly assign a mediator in this matter. And once you get the notice from the mediation clerk as to who that mediator is, Mr. Perkins, you're going to have to contact them because you're the plaintiff, the moving party, and set up a time when you can meet. The court will set June as the mediation date. So
Okay.
you have to set it up for the mediation to occur in June. And then the court will set a settlement conference in this matter for July 15th. So you'll have to be back, you'll take care of mediation in June, and then you'll have to come back to court on July 15th at 1:30 p.m. for the settlement conference, okay?
Okay.
Okay. Can I add one thing? Was I supposed to be served with a default notice? Because I never was.
That should have been sent out to you, yes.
I never received that.
Okay, well, you know the default was entered, so the default's been entered, so Mr. Perkins, if you didn't, make sure that you make a copy and send that to the defendant. But notwithstanding that, the failure to serve does not, again, defeat the default. The default still is valid.
Well, Your Honor, is it all right if I say something? Or?
Yeah, go ahead.
Well, I don't recall receiving any letter for a default. I actually just went down to the courthouse after the 21 days, after she did not comply with the divorce papers. And then I was told to go to the friend of the courts, which I'm still waiting on a response from them. And
you filled out the paperwork for a default because it's in the file.
Yes.
And as I stated, the default occurred on January 30th, 24. So you did get the copy of the default.
Oh, okay. I was thinking this was something that was mailed to me. My apologies.
Nope. When you have to send it, you have to serve the defendant with that. So serve her with a copy of the default.
Okay.
But ma'am, what I'm gonna do is, as I said, let you participate in the disputed matters. And we've set the mediation and the settlement conference date. So ma'am, because you are the moving party, you're gonna have to do an order and submit
Okay.
that within 7 days, which allows you to participate in disputed matters, setting the mediation for June and the settlement conference for July 15 at 1:30 p.m. Okay?
What is the order called that I'm supposed
The
to?
order is just what I just told you, the order has to say.
Okay.
And if you are uncertain, you can go back through YouTube and you can look this up again so that I don't have to repeat it a third time, okay?
All right.
Okay, thank you. You're free to go. Have a good day.
Thank you for your time, sir.
Edwards versus Gregory Edwards. Today is Monday, April 29th, 2024 at 10 a.m.
Court will note the appearance of Mr. Zubik on behalf of the plaintiff, Mr. Todd on behalf of defendant. The matter is before the court on the defendant's motion for continuation of order and for contempt. Mr. Todd.
Thank you, Your Honor. Your Honor, I will largely rely upon my motion. In essence, basically, Mr. McKediak has an extremely extensive criminal history. And the court originally ordered that he would have no contact with the children. It's our understanding that contact may have occurred. The answer is quite concerning. The answer indicates that plaintiff lacks information or knowledge about whether or not contact with Mr. McKediak has occurred, which is quite curious. Mr. McKediak was recently released from jail to felony possession of methamphetamine conviction. That conviction was in 2023 with an incarceration term of 1 year. Additionally, another conviction in 2023. It's listed as assaulting a pregnant individual. Apparently, it's a second offense, domestic violence charge. He has no less than 8 convictions on iChat, which only include Michigan. Another felony weapons charge, 3 assaultive convictions, and an aggravated domestic violence charge. Those convictions range from Calhoun County, Kalamazoo County, Sheboygan, to Otsego. So he certainly doesn't have any track record of being clean, stable, nonviolent, and he should not be around the children. Additionally, the answer indicates that Mr. McKediak is simply a friend. If that's the case, there is absolutely no reason why this person should be around the children. He has no relationship nor reason to be around the kids. He's not a family member or anything like that. So there's no reason why this person who has a significant criminal history of both violence and drugs to be around the children.
Okay, thank you. Mr. Zubik, what's your response?
Thank you, Your Honor. And I guess I would also rely on my answer. And as to the plaintiff lacks information, I think that was just to the idea of what at the home means. But as to any violation, absolutely not. There's been no contact. There's been no conversation between Mr. McKediak and the children. So as to the actual violation allegation, it's absolutely untrue. Further, Mr. McKediak, although he has been released from prison, he's been on probation, he has been attending domestic violence classes, he has been attending substance abuse classes, all to better himself. And he is, as a friend, to say that he doesn't have to be around them just because he's a friend. I also mentioned how the children are friends. The children they hang out quite a bit. And he even wants to, be able to start going to church. And Miss Edwards also wants to start go to church, all of them together. And further, as to the movement's claim that the reason they don't want Mr. McKediak around the children is because a felony conviction is hand in hand with being unsafe to be around the children. I'd like to bring up that Mr. Edwards was in an extramarital affair with a lady named Tiffany Markard, who he knew was a convicted felon, and brought her to the marital home when one of the minor children were very young. Another person that was around the children was Christopher Edwards, who's the brother of the movant, who the children would visit him at the home and have overnights at his home, and he's a convicted felon as well. Finally, the defendant's late uncle, Charles Edwards, who was a convicted felon who was convicted of child molestation, was also around the children and under the direction of Mr. Edwards. Further, there was a prior judgment of divorce in Mr. Edwards' prior marriage that explicitly stated through his ex-wife's demand that they would not be around his late uncle, and he did not abide by that either. So I think that the hypocrisy is essentially rampant here with what the real reasoning is between them not wanting to be around him, not wanting the children to be around Mr. Makediak.
Okay, well, court's not going to engage in a tit for tat for past again actions in this matter. I'm dealing with what we have now. The court had previously, under a temporary order of January 30, 2024, ordered that Mr. Makediak would have no contact with the children. Again, based upon his record, I don't know what these other felonies other people have had, but clearly Mr. Todd has laid out his issues, and the court will continue the no contact provisions for Mark Makediak, and that he not be around the children. You have no contact with the children. Mr. Todd, you can prepare that order and submit it under 7 days.
Thank you.
Okay, thank you. Free to go. Have a good day.
Thank you. Yeah.
Jacob Smith versus Megan Wenzel. Today is Monday, April 29, 2024 at 10:07 a.m.
Court will note the appearance of Ms. McNiff on behalf of plaintiff, Ms. Pagano on behalf of defendant. I guess I'll ask you first, again, the matter is before the court on the defendant's motion for denial of parenting time. I guess, Ms. Pagano, if you would, in paragraph 8 of your petition, you state that defendant asked for midweek parenting time visits. Is that accurate?
My client is the defendant, and during spring break, she did ask for the midweek visit.
Okay. I thought because he has custody, I thought, how's he denied parenting time if he has custody?
No.
Okay.
So.
Okay, got that. Guess I'll ask Ms. McNiff, as you are representing the plaintiff, we are scheduled for trial on Thursday. Is that proceeding at this point?
It is, Your Honor.
Okay, Ms. Pagano, is that your understanding?
It is, Your Honor.
Okay, well, what we're gonna do is, because obviously we're gonna need to take some testimony, et cetera. The court will put this matter over and we'll address this at the time of trial.
Okay.
Okay.
Okay, thank you. We'll see you on Thursday.
Thank you, Your Honor.
Court will note the appearance of Ms. Kirkpatrick on behalf of the plaintiff, defending appearing in pro per. The matter is before the court on the plaintiff's motion to amend parenting time order. Ms. Kirkpatrick.
Yes, Your Honor, this is a post-judgment motion to change the parenting time in this case. And we are working from a judgment of divorce from June 16th, 2017. There are 3 children, 15, 10, and 7 currently. They live in my client's primary custody, go to school here in Kalamazoo County. What has occurred recently is that there's an issue regarding the supervision that the defendant is providing for the children when they're under his care. And there was an incident earlier this year with regards to he leaving the children home alone, his children and his girlfriend's children, and the girls had gotten into liquor and because they were unsupervised, and my client was contacted by the daughter who was very upset about the situation. It looks as though Mr. Akins likes to use Addison, who's 15 years old, as the supervisor or the babysitter for all of the children together when he and his girlfriend go out and leave them alone. That's a lot of children for her to be watching, especially overnight or late into the evening, such as that particular day. On this situation, Children's Protective Services was contacted, not by my client, but by someone else in regards to the supervision that he provides. The does live approximately an hour away from my client at this point in time. He's moved 3 times and with 3 different women since entry of the judgment. And the circumstance that he is providing in the home for them is uncertain if it's going to occur, and he just keeps moving them to different places. Now, we understand that he intends to marry this current one, but we believe that he does not provide appropriate supervision or home life for the children, and the children are becoming more and more uncomfortable with the situation as time goes on. We do not believe that it is appropriate to use the oldest child as a supervisor or a babysitter for all of these children. And it's our understanding that that is what he plans on doing this summer with all of the children while he and his fiance are at work. And so we're asking that there be an evidentiary hearing, that there be a change of parenting time made in this matter to reflect a different schedule for the summers, that he be ordered not to use the oldest child as a daycare provider for the children. And as I indicated, that there be proper supervision made for the children while they're in his care. We would like, until there is an evidentiary hearing, that his extended parenting time be suspended.
Okay, thank you. Mr. Akins, what's your response?
They have never been left alone overnight, ever. As far as the alcohol, no Child Protective Services was ever called. That was my fiance's ex that called for a whole different reason. That was already taken care of. There's a case number completed. They found nothing wrong with it. I was joking with Addison when I told her she would have to babysit all the kids. You're right. I did say it jokingly. We were all laughed. There are 2 15-year-olds here. Yeah, and if they were to stay the summer home while we're at work, there's 2 15-year-olds here for 6 kids. They all take care of themselves. And as far as the alcohol incident, I made them dump every bit of alcohol we had in the house out. I don't condone drinking in the house for minors. They dumped every ounce that we have in the house out. And as far as me being gone, there's been 2 times I've been gone besides grocery shopping when I asked them if they would want to go with us, and they do not want to go grocery shopping. There has been 2 times besides grocery shopping when I left them here. And yes, we are getting married in August. And I also asked Lisa if I could have the kids for that time, with no response yet.
Okay, well, you have to work that out. Okay, anything else, sir?
That's what I got.
Okay, well, the court will find that it is not inappropriate to leave the kids with 15-year-old to babysit for a short period of time. The court would state that, again, it wouldn't be appropriate if the 15-year-old is stuck doing the extended parenting time in the summer for the entire time the parties might be working. But as Mr. Akins had stated, for the times that they've went and got groceries or went out for a limited period of time, that's not inappropriate. So the court doesn't find any basis to change the parenting time on that particular basis. And as a result, the court is simply going to caution Mr. Akins, don't have the 15-year-olds providing the daycare for the entire time that the children are with you in the summer, because kids do get into different things, and it's questionable as whether the 15-year-old could supervise kids for that long of a period of time. So I'll leave that up to you, and if something else comes up, then I'm sure the matter will be back, but I don't find any basis at this time to modify parenting time, so I'm going to deny the motion. Mr. Akins, you're going to have to do, as you're the prevailing party, you're going to have to do an order denying the motion and submit it within 7 days, and then that'll get entered at that time.
Do I do that in the court or the courthouse?
Yes, yep.
All right.
Or you can prepare it at home and then just file it, but all I'll do is just say, title it, order denying motion, and state, reference the motion, state that it was heard on today's date and that the court denied it. Okay?
All right. Thank you.
Thank you. You're free to go.
Bye.
Gary Vandeveter DuPonts versus Chris DuPonts. Today is Monday, April 29th, 2024 at 10:27 a.m.
Court will note the appearance of Ms. Reed on behalf of the plaintiff. This matter is before the court on the defendant's motion to show cause. Mr. DuPonts, did you receive Ms. Reed's answer?
I did, Your Honor.
Okay. And have you been able to confirm that, at least as it relates to the Bateman land contract, that that's been taken care of?
Yes, Your Honor. We're satisfied with the proofs they gave us.
Okay. Only thing I guess is, Ms. Reed, is it looks like when I reviewed the judgment that we did not address the 100 and the 98 South Helmer Battle Creek properties as well.
I believe that those are same properties in the Sturgis note and the land contract, and those have all been resolved, and those are not in Mr. DuPont's name.
Okay. Mr. DuPont, are you satisfied that those properties are covered as well?
I am with the documentation they provided. Yes, Your Honor.
Okay. So everything's taken care of at this point, correct?
No, Your Honor. There's still an outstanding note on the marital home at 2041 Oak Lane.
Okay. And that note is with who?
That is with Kellogg Community Credit Union in the
Okay.
amount of 241,767.69.
Okay. Ms. Reed, what's your response to that?
In a response to our motion, we attached a letter from the lender that my client attempted to refinance through. She started that process in December. The holdup on that refinance was first getting verification that past due taxes have been paid, and we got that verification, I believe, the end of February, and that we needed documentation that my client had received pension payments from Mr. DuPont's pension. There was a delay in that as my client's prior attorney made some additions to the DRO that was not acceptable by the plan administrator. We made those corrections. I sent them over to Mr. DuPont's attorney in February. We did not get that back signed by Mr. DuPont's or his attorney until the middle of this month. That DRO was signed by Your Honor last week. So we do not have verification yet of those receipts, because now they'll have to go to the plan administrator to be processed, and that can take up to 30 days before my client can receive any payment. And the last thing that the lender is waiting on verification for is that my client is not paying child support. We've had to adjourn the child support hearing this matter twice. It was originally scheduled in February, and we adjourned that so that we could have the parties complete their 2023 taxes and exchange all the income information for that. And then it was scheduled again last week or the week before, and that was adjourned because Mr. DuPont has not done his 2023 taxes yet and has not provided my client's accountant with income information regarding her share or her payments from, I do believe it's patent pads and properties on a K1 or some other form of partnership tax form that the accountants need. So that hearing is now adjourned out till July. So the outstanding things that the lender needs, and she's already pre-qualified and pre-approved for this refinance, they're just waiting on documentation that she's getting pension payments and a child support order. So we're requesting that Mr. DuPont's request that the home be sold be denied because he is the one that's causing the delay in the refinance. And we're also requesting that he provide the required documents to the accountants within 14 days so my client can do her taxes and we have everything prepared for the July hearing because we do not want to redo it again.
Okay. Mr. DuPont, can you provide that information the account needs within 14 days?
He's working on it. He's close to having it done. It's quite substantial because of the settlement. So he's needed time to do that.
Okay, well, I just want to know, because I want to put a deadline on it. If he can't do it in 14 days, can he do it within 30 days?
30 days would be fair.
Okay.
Yes.
The court will then order that the accountant would, again, the information, anything you have to provide, the accountant would be provided with it within 30 days, and hopefully the accountant can have that completed at that time. And then I guess at such point as we have resolution of the support issue as well. And that's the one that's coming up in July, Ms. Reed?
That is correct.
Okay. That, in fact, once we have that order, that she would, the plaintiff would provide that to the, I guess, the credit union, be able to complete that refinancing. Are those the only two things we need then before completing this?
That's my understanding. It's just we need to wrap up child support. And once the DRO is sent to the administrator and payments start going to my client, that should satisfy the lender.
Well, if we're taking care of the support issue in July, I would assume she would get word before that time on the QDRO.
Hopefully, but it is the state plan administrator and they take a little bit.
Okay, well, anything else, Mr. DuPont?
Yes, I gave her a settlement of $523,117. It's very unfair that I've complied with the judgment, and now this is causing me harm. I mean, we're 30 days past this, and this should have all been resolved. I didn't have the issue with child support, which the FIF comes in at like approximately $50 a month, right? It's like $600 a year. And in addition to that, the plaintiff makes enough money to afford this, especially with a settlement. And now I'd like to refinance and get into a proper home for my daughter and I.
Okay.
And I've got the shadow all hanging around.
Well, I understand that, but again, as the court reviewed the judgment, I saw that there was no provision for the refinancing on the Bateman or the other two in South Helmer, so I can't hold her in contempt if the judgment didn't provide that she had to refinance those within 120 days.
Yeah, I believe it did address Van D LLC, which is the entity which holds that note, but I would have to check, Your Honor. I'm not sure.
You have to check, but it didn't provide that she required to refinance that within that time. So I can't hold her in contempt. Ms. Reed, you can prepare an order stating that again, that the issue of the support will be resolved in July, and that as well as he, like I said, with regard to providing the information so the accountant can get that completed. And then at that point, again, if it's not done in July, then Mr. DuPont, you can renotice your motion at that point.
Yes, Your Honor.
Okay. Thank you. You're free to go. Have a good day.
Thank you.
Court will note the appearance of Ms. Podolsky on behalf of defendant. This matter is before the court on the plaintiff's objection to the proposed order. The basis, Mr. Clark, you state in there, I wish to have custody and parenting time. Is that the basis for your objection?
Yes, sir.
Okay. Well, Ms. Podolsky has filed an answer in this matter, and again, your wants or desires are not a basis for objection. The objection would be if the order did not properly reflect the ruling of the court. And so the court is going to deny the objection as it is not a proper objection. Ms. Podolsky, you can prepare the order denying the objection.
Thank you.
Okay, thank you. Yes, that order is in place, isn't it, You have the order here?
I have.
Yeah, we'll enter that order then.
You'll, the order.
Yes,
The previous motion. Do you
Yeah.
need, no order for today then?
no,
Okay, thank you.
thank you. Court will note the appearance of Ms. Thomas on behalf of plaintiff, Mr. Moss on behalf of defendant. This matter is before the court on the plaintiff's motion for order of temporary custody support parenting time. Ms. Thomas, just to clarify, in paragraph 7 of your motion, you state that the plaintiff was arrested for domestic violence. Did you mean the defendant?
I did, I'm sorry.
Okay, I just wanted to clarify. I thought that was inconsistent with the other, and I want to make sure.
It would have been, yes, I'm
Okay.
sorry.
Okay, go ahead, Ms. Thomas.
Thank you, Your Honor. Your Honor, as the court, I'm sure has read both the motion and the answer, the parties have one minor child, Lyra, she's age 4. That parties have a very tumultuous relationship. They separated on or about February 8th, 2024, and that was after a domestic assault in which defendant was charged with domestic violence. The plaintiff was fearful for her safety and the safety of the minor child, so she moved with the minor child from Lansing to Battle Creek, where she and the minor child presently reside with the plaintiff's parents. After the defendant was charged with domestic violence and a no contact order was entered, the minor child's grandfathers actually worked together to ensure that defendant and his family did have continuing contact with the minor child in the home of defendant's parents. However, the transportation was left totally to the plaintiff's family to get her to Lansing, to retrieve her from Lansing, etc. Ultimately, the charges were dropped as plaintiff chose not to pursue the matter, hoping to work out with defendant the ability to co-parent Lyra. Unfortunately, that does not appear to be the case. Defendant is still apparently continuing with anger issues, and the parties are barely civil to one another, let alone able to work together for the best interests of their daughter. Historically in their relationship, the defendant has bullied plaintiff into submission and ridicules rather her about her lack of intelligence. The defendant's increased use of alcohol over the past few months have escalated the situation, and the unrest between the parties was continuing to grow to the level that it hit in February when in fact the defendant was arrested. Although defendant appears to allege he has no more than 3 12-ounce Budweisers on the day that he was arrested for domestic violence, plaintiff certainly appears differently and indicates as well that Mr. Templeman drinks a lot of alcohol and not just beer. He drinks significant amounts of hard liquor as well, including in the presence of the minor child. Although defendant's answer denies multiple domestic violence incidents and perhaps prefers to have them referred to as altercations, he acknowledges law enforcement was called repeatedly to the party's home, obviously showing that there is unrest between these parties. Defendant would have this court believe that plaintiff was eager to have communication with defendant after the no contact order was lifted. However, any desire she had to have contact was solely to make sure that if Lyra were to be in his sole care, that she would be safe and that he was not continuing to drink with Lyra present. Obviously, his parents have been involved in the parenting visits during the period of the separation and while the no contact order was in place, and she was a little concerned that well, she was very concerned actually, that would Lyra be safe in his care if his parents weren't part of that parenting time. As to the best interest factors, plaintiff does confirm her statements as set forth in her motion. She further states that for most of Lyra's life, she has been a stay-at-home mom, and although defendant now alleges he has concerns about the care and safety of the minor child in plaintiff's care, and specifically alleges mental health issues, he has never had a problem leaving the minor child in plaintiff's care when he went to work every day. Yet now he questions her ability to care for the minor child and is requesting supervised parenting time, but also admits plaintiff is well able to give and provide the minor child with love, affection, and guidance and other emotional ties existing between the minor child and her parents. Yet also states she is not morally, mentally, and physically fit to provide for the proper care of the minor child. Which is it? Defendant is showing his words and his actions do not match, and for that matter, even his words and his words do not match. With daycare expenses compared to the minimal pay positions plaintiff has been able to obtain, it was much more practical for the most part for plaintiff to stay at home. And she was in fact a stay-at-home mom for the majority of the parties' time that they lived together, which was shortly after Lyra's birth. When that was a situation, though, defendant had expectations, though, that plaintiff was the maid rather than a partner and a co-parent in the relationship. It was telling to the plaintiff that Mr. Templeman believes that irresponsible consumption of alcohol has no bearing on a party's moral fitness as a parent, which is what is stated in the defendant's answer. Certainly choosing to drink to excess in the presence of a minor child is not distinctive of high moral character. Plaintiff presently maintains her employment with Firekeepers Casino Hotel. She's able to provide for Lyra with a safe and stable environment in the home of her parents until she's able to save enough money and or defendant begins regularly contributing toward Lyra's financial needs pursuant to the Michigan Child Support Formula. It will take her a while to get reestablished and resituated, but her parents have plenty of room in the home and have welcomed her and Lyra into their home, in which they have been in for a long time. It's a environment that Lyra is certainly familiar with. She's been there many, many times. She was regularly stayed there when the parties were residing together. So any concern that Mr. Templeman may have made regarding her safety or care in that home is disingenuous for certain. It has been typical for Mr. Templeton to not allow plaintiff to have a voice. If she disagrees with his decisions, he simply does it his way, and plaintiff does not believe the parties, unfortunately, are able to make joint decisions right now, as defendant has historically bullied the plaintiff if she didn't comply with his wishes, and she's just fearful that continuing to do so regarding Lyra-related decisions. She just does not believe at this moment. She's hoping that it will change, but at this moment, on a temporary basis, she does not believe the parties can make joint decisions together. Therefore, plaintiff is requesting at this point a continuation of the longtime status quo wherein she was the primary caretaker as a primarily stay-at-home mom with Lyra, and grant her primary physical custody with reasonable parenting time with defendant, so long as there are controls on his ability to drink during or for periods prior to his parenting time. She is also asking for temporary sole legal custody of Lyra until such time as the parties are able, hopefully with the aid of counsel, we can work on a plan for Lyra's best interest involving how joint decisions can be made as far as legal custody. But at this point in time, it just doesn't seem possible. Also, we would ask the court to order that both parties exchange their income information, so child support may be set pursuant to the Michigan Child Support Formula. And we would specifically note that we don't believe that there's any reason to send that to front of the court. That is just in a significantly long delay at this point in time based upon their workload, and that doesn't seem necessary when there's two attorneys on the case and the parties can simply exchange information and determine what child support should be pursuant to the formula. Thank you.
Thank you. Mr. Moss?
Thank you, Your Honor. May it please the court. Regarding our response, I apologize. I was recently retained, Your Honor, and got the response to the court Friday afternoon. So I'm not sure if Your Honor has had an opportunity to review that yet. And this morning, I submitted a revised version, which is identical, except I realized the filing on Friday did not have my exhibits attached that are referenced within.
I noted that you referenced the exhibits and I couldn't find them. So.
Okay. Yes, thank you, Your Honor. So I guess regarding the allegations of the domestic violence, as counsel informed the court, plaintiff did not appear at the last court hearing in that criminal matter. Those charges were subsequently dismissed. More importantly, in my exhibit A is a text message that Ms. Young sent to a family friend, in which she indicates that there was no that Ryan didn't do anything to her. And she goes on to reference that the photo that the police had of her neck and were using as evidence, but it was a photo of her skin condition. If he had laid a hand on me, there would be a bruise the next morning, which there wasn't. So I think in regards to words not matching words, I think Miss Young's words are not matching her words in regards to those specific allegations. Further, while the no contact order was in place, there was no violation of that order made by Mr. Templeman. Additionally, during the entire pendence of the criminal charge, the parties continued to exchange the minor child. Mr. Templeman would exercise parenting time on a weekly basis from Wednesday through Saturday. He would occasionally spend time at his parents' house, as he comes from a close-knit family, but his parenting time was not supervised by his parents. Regarding plaintiff's claim that she was the sole care provider, the parties lived together for over 2.5 years, approximately 2.5 years since the birth of the minor child. During that period of time, both parties equally partook in their care and raising of the minor child. While it's true that Mr. Templeman did work outside of the home, when he was at home, he would partake in feeding, nap time, putting the child to bed, changing diapers, all of the normal duties that come along with being a parent. Regarding plaintiff's request for sole legal custody, while she indicates that the parties are unable to effectively communicate right now, there's been no indication or examples given of any important decisions regarding any of the matters related to joint legal custody where the parties have been unable to reach a consensus. Therefore, we think that that request is unfounded. Additionally, regarding the allegations of Mr. Templeman's use of alcohol, Mr. Templeman is obviously over the age of 21. He acknowledges that he would occasionally after work have some beers. There has been no indication, and Mr. Templeman vehemently denies any irresponsible use of alcohol, such as drinking and driving. With reference to the moral fitness of the parties, the statement that I made was that Mr. Templeman feels that the responsible use of alcohol has no bearing on his moral fitness as a parent. Regarding the safety of the minor child while in the care of, let me back up. While the parties were together, Ms. Young, while she indicates that Mr. Templeman did not have his concerns previously, the same could be said of Ms. Young. There's no indication that there was ever any issue of Mr. Templeman's parenting time or his ability to parent the minor child while the parties were together. It's only since she's moved out of the home these concerns have surfaced. The best interest factors, ultimately the friend of the court is going to make a determination of those, but I think most significantly for the court is my attached exhibit B, where in which we reference the parties' ability to foster a positive relationship with the child and the other parent. Ms. Young recently, as of April 25th specifically, sent Mr. Templeman a text message in which she states, "Don't worry, I'll make sure Lyra doesn't remember you, and I'll make sure she remembers a real man as her father," clearly indicating that she has no desire to foster a positive relationship between the minor child and Mr. Templeman. Your Honor, for all of those reasons, it is our request that this court deny Ms. Young's motion. We would ask that the court consider granting Mr. Templeman primary physical custody and joint legal custody. In the alternative, we'd ask that the court order the status quo continue, that being Mr. Templeman having parenting time on a weekly basis from Wednesday through Saturday until a friend of the court can hear the matter.
Okay, thank you. Well, in this case, the court's heard the testimony as well as reading the pleadings. It does appear that the plaintiff was a stay-at-home mom for majority of the time that the child has been alive, and the child has been with the solely with the plaintiff since the separation back on February 8, 2024. So the court is going to maintain the status quo. The court is going to grant custody, temporary custody to the plaintiff. Support will be pursuant to the guidelines. The parties will exchange income information within 7 days of today's date. The court will grant to the defendant standard parenting time, alternating weekends, midweek, alternating holidays. And the court will order that during the time that the child is in the defendant's care, that he would not consume any alcohol. And that the court would order that the parties would participate and communicate through our family wizard in this particular case. With that, I'll ask Ms. Thomas that you would prepare the order, and I was going to say submitted it under 7 day, but it depends on if you get the income information in that time.
Okay, so if we're going to exchange the income information within 7 days, can I have 7 days beyond that to submit it under the normal 7 day? Is that acceptable to the court?
I'll allow you to do that 7 days from next week, so that we can again, we don't have to schedule another hearing in this matter.
Okay, perfect. Thank you so much, Your Honor.
Okay, thank you. You're free to go. Have a good day.
Thank you.
Thank you, Judge.
Court will note that this matter is before the court on the defendant's motion to set aside referee order. It appears, Mr. Taylor, that you're basically saying in that you said you have the child for several hours during the week, and that she's on disability, and therefore should be some modification, correct?
That was correct, Your Honor. However, events over the weekend have made that old news. Bella has now been returned to my care and is living with me full time.
Okay. Well, what you're going to have to do with that in mind, you're going to have to file a motion to modify custody, because again, just telling me doesn't satisfy the court rules, et cetera. So you're going to have to file a motion to modify based upon those circumstances.
Okay, the change in personal information isn't sufficient?
Excuse me?
The change in personal information is not sufficient?
Well, what happens is you're saying that, again, you have a child in your care. You're going to have to spell all that out, and you have to file a motion for change in custody, and you spell out the basis for the motion for change in custody. And then what we would do is we'd have a motion hearing. If she agrees with that, then there's no need for an evidentiary hearing. If she disputes it, then we're going to have an evidentiary hearing.
Well, Sunita, okay, all right. Sunita,
Unless if she is agreeable, you can always prepare an order, modifying custody, parenting time, support. And if she signs the order, it's a stipulation, and you can enter it simply by order, and then you can bypass the motion if she's willing to cooperate.
Oh, I don't know if Sunita's Bella's been living with me for the past 8 years or so, me and her older sister, and I've been doing the sole parent for them the entire time. And then an event happened over last summer, and it caused Bella to be living with my parents, her grandparents, for a minute. And that's,
again, all of this doesn't change the fact you need an order to change custody, or you need a motion to change custody.
Okay.
I can't do it based upon simply what you're telling me today, because it's not evidence.
Okay.
Okay.
All right.
Thank you. You have a good day. Court will note that this matter is before the court on the plaintiff's motion to terminate the personal protective order. Defendant or plaintiff in his pleadings has stated the parties are going to counseling and believes that they can work matters out. I guess I'll ask Ms. Williams, is that your understanding in this matter, or what's your position?
Yes, that's my understanding.
So are you agreeable with terminating the PPO?
Yes.
Okay. You understand that, again, there's no requirement that you do so, and that you can keep it in place. You understand that. Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to terminate the personal protective order?
No.
No, I'm asking Ms. Williams.
No.
And are you doing so freely and voluntarily?
Yes.
Okay. Court will, based upon your assertions, the court will, in fact, terminate the PPO in this matter. You understand, Ms. Williams, that at any point, should it be necessary in the future, you have a right to file a petition and seek a PPO at that time.
Yes.
Okay, thank you. We will get that terminated and completed, and best of luck to you. I hope everything works out for you.
Thank you, sir.
Have a good day.
Thanks.
And the petitioner is not here.
This matter is before the court on the defendant's motion to terminate the personal protective order. He states in his motion that the petitioner had made contact with him, that they had gotten together to discuss various parenting time issues. That he also states that on March 30, 2024, that the petitioner assaulted him. And again, the court notes it is now 11:11 a.m. It was set for 11 o'clock. The petitioner has not appeared in this matter. And on that basis, Mr. Mix, the court will grant your motion as the petitioner has not appeared to respond to your petition. Anything else, sir?
No, that's pretty much it. Thank you, Your Honor.
Okay. I'll let you know that, again, just because I've terminated doesn't mean that she can't refile in the event that it's necessary, nor are you prohibited from filing. If she in fact did assault you as stated, you have a right to file and seek a personal protective order as well. You understand that?
Yes, I do.
Okay. Okay, thank you. We will get those orders entered and out, and that will conclude the case at this time, sir. Have a good day.
All right. Thank you very much.
All right, thank you. We'll close the record here.